All right, in our last video, we said your first sentence should always be, the First Amendment protects freedom of speech, including freedom of the press, freedom of speech, freedom of assembly, and freedom of association. We talked about protected speech. Content-based gets strict scrutiny. Content-neutral gets intermediate scrutiny. We talked about unprotected and lesser protected speech. Now we're going to get into that a little bit more. We talked about public forums, limited or designated public forums, and non-public forums. But let's talk about some other things. Prior restraint. Prior restraint is a prohibition on speech or publication before it occurs. What level of scrutiny? That's right, strict scrutiny. Prior restraint equals strict scrutiny. They prevent expression before it occurs. What is the most common type of prior restraint? You guessed it, it's an injunction. That is very, very difficult to get. How many times have you heard of an injunction against speech that might happen? So a prohibition on speech before it happens has to be narrowly tailored to serve a compelling government interest. Okay, so does this mean, injunctions being our most common type, difficult to get? What about permits and licensing? Well, the government may require licenses or permits if it's reasonable, if there's a reasonable justification for doing so. If there's a reasonable justification for doing so. It cannot be discriminatory. Okay, what about vagueness and overbreadth? Okay, so a law can be unconstitutional if it is vague, if a reasonable person can't tell whether the speech is prohibited or permitted. Okay, so for example, a law protecting people from standing on the sidewalk in a manner annoying to passerby is unconstitutionally vague because a reasonable person has to guess as to what behavior is punishable. Vagueness. A law is vague if what? That's right. A reasonable person can't tell whether a speech is prohibited or permitted. How about overbreadth? A law is overbroad if it regulates substantially more speech than allowed. Okay, so if we're going to prohibit all live entertainment or all words deemed obscene, we could actually argue that one was vague and overbroad. Okay, so one of the most important things here is that fighting words statutes are almost always unconstitutionally vague and overbroad. Okay, but let's go over the definition for vagueness. It's vague if a reasonable person can't tell if it's permitted or prohibited. I don't know what's prohibited or permitted. It's too vague. What is annoying? How do you know? Whereas overbroad, if it's regulating substantially more speech, so it's restricting speech, and in doing so, it restricts both protected and unprotected speech. It's overbroad. It regulates too much. Okay, so if we want to prohibit all live entertainment, and the purpose of the law is to protect nude entertainment, well, what are we also prohibiting? Speech in concerts, speech in theater, it's overbroad. It protects too much. Okay, now let's talk about fighting words and incitement of imminent unlawful activity. These are categories of less protected speech. Incitement of imminent unlawful activity. So we don't do clear and present danger anymore. The government may regulate the speech if there's a substantial likelihood that the speech will bring about imminent illegal activity, imminent lawlessness. There's a substantial likelihood that the speech will bring about imminent illegal activity, and it's aimed at doing just that. So, overthrow of the government, for example. Okay, so what's the test? It is strict scrutiny. Strict scrutiny. In the United States, we are allowed to talk about communism. We are allowed to burn flags. But if we are imminently asking someone to go burn down former President Trump's house, likely that is incitement of imminent unlawful activity. Okay, fighting words. This is something that's going to cause an immediate violent response. And it's virtually impossible for a fighting word statute to be upheld because it will be overbroad, regulating too much speech, too vague, or it's content based. And it's going to fail strict scrutiny. Okay, so incitement of imminent unlawful activity is substantial likelihood that that's right, the speech will bring about imminent lawlessness. And the speech is aimed at causing, that's right, imminent lawlessness. What does it have to pass? Strict scrutiny. Fighting words, immediate violent response. What do we have there again? Fighting words, immediate violent response. Why is it hard to get a fighting word statute upheld? Because it'll be overbroad, it'll be vague, or it'll be content-based and fail strict scrutiny. Okay, obscenity, appealing to the prurient interest in sex. Okay, it's obscene if it appeals to the prurient interest, it's patently offensive, and it lacks any serious literary, artistic, political, or scientific values. Okay, let's talk about this one one more time. Obscenity, appealing to the prurient interest in sex. How would the average person view the material as a whole? It's patently offensive in its sexual portrayal. And it has to specifically, any law that prohibits that must specify what's patently offensive. And 3, taken as a whole, it lacks any serious literary, artistic, political, or scientific value. Okay, 3 prongs. Number 1, appealing to the prurient interest in sex. Number 2, it is patently, that's right, offensive. And 3, taken as a whole, what does the material lack? Any serious literary, artistic, political, or scientific value. Okay, so does this mean that we can't have nude dancing? Well, no, because the government can use zoning to regulate that if the zoning is designed to combat the secondary effects of that type of speech. So if you want to have a nude bar or a strip club, zoning regulations are valid. Zoning regulations are valid if they're designed to combat the secondary effects. So what are the secondary effects? Increased traffic, drop in property values, rise in crime. Okay, what about pornography? People have pornography all the time, and that's technically sometimes obscene. Pornography is not obscene unless it involves kids, period. Pornography is not punishable as obscenity unless it involves children. Okay, profanity. Can you say the F word? Well, yes, generally that's protected. Okay, we talked about commercial speech. Remember, if it's true, it is generally protected. But if it's the threshold question is it false? Is it misleading? Is it deceptive? Is it illegal? Does it talk about illegal activity? Then the government can regulate it. Remember, protected commercial speech, that means it's not misleading, not unlawful. can be regulated under intermediate scrutiny and no more extensive than necessary. So this is a pretty lenient standard. So vice advertising, alcohol, cigarettes. What about attorneys? They can't say I'm going to win your case, right? But they can say how many cases they've won. So protected commercial speech, we're going to look to see if it's protected. If it's protected, it's not misleading, it's not unlawful. Past rational basis review, not more extensive than necessary. If it's false, misleading, or deceptive, illegal, that's not protected. Okay, defamation. All right, so remember, defamation is a false statement published to a third party, and it harms the plaintiff's reputation. That's the private person tort standard. Okay, so let's talk about public figures. Okay, a public figure is just someone who has fame or notoriety, not just a public official or a public office holder. And a matter of public concern is a statement that relates to some sort of national or community interest. Okay, so if the defamation, the false statement, intentional false statement involves a public figure, the plaintiff, that would mean the public figure, has to prove it was false. And they have to prove fault. The defendant was at fault. Okay, public official, actual malice. Private figure, negligence. Public official, actual malice. Private figure, negligence. Okay, so if it's a public figure, someone who is like Senator or Taylor Swift. Taylor Swift is a public figure. And it's a matter of public concern. If Taylor Swift wants to speak about matters pertaining to the national interest, she certainly can. But if someone defames Taylor Swift and makes an intentional false statement about her, and she wants to sue them, she has to prove it was a false statement, and she also has to prove fault. Now, what's Taylor Swift? She's a public figure. So she would have to prove the statement was with actual, that's right, malice. What if it's just a private figure, a private person? It's just a negligence standard. Okay, so remember, for a private person, we just have the torts standard for defamation. For a public figure, the plaintiff has to prove it was false. The plaintiff has to prove the defendant was at fault. If we have a public figure, public official, the standard is actual malice. All right, and that is all for part 2 of freedom of speech.